Vehicle safety, compliance and O-licence protection is a key objective for transport operators. That's why we caught up with Peter Gale, founder of the transport consultancy 2 Roads Limited. Peter is a qualified DGSA, DFT approved trainer and JAPT approved DCPC trainer. Peter spoke to us about the importance of compliance and the 14 undertakings operators must meet as part of their O-licence requirements.
The operator occupies a position of trust and responsibility. You have a responsibility to staff and to other road users for the large vehicles that you run on UK roads. A large level of trust is placed in you as an operator, and that's why checks are not regularly made. It's for these reasons that good repute is so important, and why that good repute is lost if you're convicted of certain offences or found to be in breach of the trust placed in you. In particular, you're trusted to comply with 14 undertakings given when you apply for the licence. Can you list them? Are you sure that you have compliant procedures? In this video we will only touch on those undertakings. However, over the course of the next few months, Alltruck will provide complimentary seminars that you may attend in order to develop a deeper understanding of each undertaking. You have undertakings to ensure that the laws relating to the driving and operation of vehicles are observed, that the rules on drivers' hours and tachographs are observed, proper records are kept, and that these are made available on request. To ensure that vehicles and trailers are not overloaded, that vehicles operate within speed limits, that vehicles and trailers are kept in fit and serviceable condition, that you have an effective driver defect reporting system, that records are kept for 15 months of all defects, all safety inspections, all routine maintenance and all repairs to vehicles, that you do not exceed the maximum number of vehicles and trailers authorised for each operating centre, that an unauthorised operating centre is not used in any traffic area, that the Traffic Commissioner is notified of any convictions against the licence holder, their employees or agents, and of any material changes. For example, a change to the proposed maintenance arrangements or a change in the financial status of the licence holder that might affect the licence. There are obligations for standard licence holders to keep at least one vehicle in use and to utilise adequate real premises with records of accounting and personnel. And there are other requirements. For standard licence holders, professional competence, and for all operators, good repute and financial standing. As we start to discuss these points, we begin to open up debate and raise some interesting questions. For example, if asked what arrangements you're making to ensure that your vehicles are operated within the speed limit, could you give good evidence? Are speed limiters enough? What about in 30-mile-an-hour limits? If you employ drivers with more form than a racehorse and you've no evidence of speaking with them about their convictions, then you may have a problem evidencing that point. Here are some more very common stumbling blocks. Is it enough to get drivers with infringements to sign a letter acknowledging them? Is that sufficient evidence to support arrangements being made that driving hours regulations are followed? Does a restricted own goods operator need a qualified transport manager? Is it the operator's responsibility to arrange driver CPC training? If your drivers don't get their driver CPC qualification, can you dismiss them in 2014? We'll discuss this in more depth on the appropriate seminar, but it's just one example amongst many. These are the types of questions that we'll raise when we start to get into detail. And we'll make meaning of the undertakings that you're trusted to comply with as a transport